here, with the Dave Hendrickson.
You may be seated. And Ms. Zenda.
Good morning, Your Honor. Ali Zenda on behalf of the people. Your Honor, the people waive the potential conflict between this honorable court and the Office of the Public Defender, while the people don't believe conflict exists. The people make this waiver in avoidance of all doubt.
Good morning, Your Honor. Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Deputy Chief Public Defender Lauren Broughton.
Permission to practice is granted.
Thank you, Your Honor. We waive any potential conflict between this honorable court and our office, and if any conflict were to arise, we waive that conflict so that this honorable court could hear these matters.
You're talking like him, huh?
He talks a lot slower.
Wow. The court, for its part, also does not believe there's a conflict either in the Michigan court rules or the cases decided they're under. To the extent a conflict doesn't exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Ardeen Henderson.
Your Honor, Alexis Plumai appearing with and on behalf of Ms. Henderson. Ms. Henderson, could you say your full name?
Hi, my name is Ardeen. My name is Ardeen Henderson. I'm at Wayne County.
Yes.
Thank you.
Now things start heating up. What began as a routine court roll call quickly turns into a tense series of legal maneuvers. We've got multiple defendants, scheduling confusion, and even some humor sneaking in from the bench. But pay close attention, because these early exchanges show just how quickly courtroom energy can shift from formal to unpredictable. You'll notice attorneys negotiating dates, judges juggling calendars, and defendants caught somewhere between nerves and uncertainty. This is the side of the justice system most people never see, the messy, human part. And it's only going to get more interesting from here. So keep watching, because one of these defendants is about to make a bold and unexpected move.
Your Honor, I apologize, filling out a green sheet right now. Just requesting a very short adjournment. I was told that there would not be a misdemeanor offer on this case a little later yesterday afternoon, and I wasn't able to set up a Zoom meeting with Wayne County in time for today's hearing to discuss waiver versus setting for exam with Ms. Henderson.
October 16th, 2025, 9 a.m.
Thank you.
What day would that be?
Under Joe Simon, on behalf of Mr. Flood, state your name, Timothy.
Timothy Flood.
Thank you.
Your Honor, Ms. Willenbringer and I have been in discussions. She tells me the matter is going to be handed off to a different APA. I've made a proposed resolution. We're asking for an adjourned PCC to continue those discussions.
That's correct.
Probable cause conference, October 9th.
Your Honor, I'm traveling that day. I know I have another one that day, but I'm actually going to have someone cover. Could we have the next available, please?
16th, 2025, 9 a.m.
Thank you, Your Honor. Wait for me. Actually, just go home. Go home.
The court calls case people versus Jamie Burke.
Your Honor, Alexis Plumai appearing with and on behalf of Mr. Burke. Mr. Burke, could you state your full name for the record?
Absolutely. Good morning, Your Honor. My name is Jamie Burke.
Thank you.
Your Honor, at this time, we are requesting a preliminary examination. To my knowledge, discovery is complete.
Where's my day? Preliminary examination without objection, October 14th, 2025, 9 a.m. before Judge Washington.
Thank you.
Thank you, Your Honor.
Thank you. Bound continue. Court does call the case people versus Amanda Lawrence. My recalls. My recall.
Your Honor, Joe Simon on behalf of Ms. Lawrence. State your name, Amanda.
Amanda Lawrence.
Your Honor, I became engaged yesterday and we substituted in
I think it's already married.
You know what the
It
penalty?
was too easy, Joe.
Do you know what the penalty for bigamy is, Your Honor?
I do. You know.
Two mother-in-laws. No, go ahead. No, sorry.
Wow.
No, that's what I heard. And anyway,
Wow. Well, you said that out loud.
I know. It's an oldie.
You want an adjournment,
It's
right?
an oldie. Yes, please.
Wow.
All right.
On behalf of Mr. Simon, I apologize. October 16th, 2025, 9 a.m. Bond
Thank
continued.
you, Your Honor.
Wow. Oh. Never mind. You're not even getting into it. Court calls the case, People versus Devontae Connor Belcher.
And on behalf of the people,
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Connor.
Guys, you're gonna have to make sure you make room for transport to get through. And pay attention when they're coming through. Your name, sir?
Devontae.
Yes.
Your Honor, we're asking to set this matter for a preliminary examination.
Discovery is complete.
Yes, Judge, to the best of my knowledge.
Preliminary examination in this matter will be in person, October 14th, 2025, 9 a.m. before Judge Valvo.
Like we heard on bond, Judge.
Briefly.
Thank you. Mr. Connor Belcher is here. I have his father is also here in court. His father has indicated that he can reside with him during the pendency of this matter. Mr. Belcher is stays in Ann Arbor. I don't think he's a flight risk in this matter. He could be tethered. I'm not going to gild the lily. His father did indicate he lives at Avalon. But I think the 14-day rule for guests would be pretty well satisfied.
This case involves a defendant stiff arming the victim in the chest and the stomach multiple times and strangling the victim. He also has told in this county he has 2 retail fraud second hold out of 1481 that's up on 1015 with the 1,010% bond. He also has been run disorderly out of 15 that's up 1023 with the 1,010%. He also has pulled out of Livonia for disorderly for $585 and Vander for fraud with 5,010% bond. So at this point, I'd be asking the property to set.
Your Honor, looking at XGL, I don't see that the out county jurisdictions would are looking to pick them up on these, and the bonds in the other cases total to $300 total.
Right. Court, in considering all of that, the court is going to deny the request to modify bond at this time. Bond will continue. Thank you.
Thank you, Your Honor.
3 cases.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Grisbeck.
Assistant Public Defender Chelsea Virgiles with and on behalf of Stephen Grisbeck.
Your name?
Stephen Grisbeck.
Thank you.
Your Honor, we're asking the court to set these cases for.
And likewise on my cases.
So all discovery is complete on these matters.
Yes, Your Honor.
To the best of my knowledge, yes, Your Honor.
People have their witnesses available the 14th. I'll take that as a yes. Preliminary examination in person, October 14th, 2025, 9 a.m. That's before Judge Washington.
Thank you, Your Honor.
Bond will continue.
Thank you, Your Honor.
Let me get this. Court does call the case People versus Alicia Cargill.
Good morning, Robert J. Killen, Cargill. Cargill, would you state your name for the record? Judge, while we're waiting, just a brief history. I did see Ms. Cargill at the prison on August 20th. On September 12th and September 19th, I went to the prison. They could not find a computer to play the disc. They finally found one and called me. I went yesterday to see Ms. Cargill to play the disc. She refused to see me. So I'm not sure where we are in this matter, Judge.
State your name, please.
Alicia Cargill.
Thank you. All right. What would you like me to do with this matter?
Ms. Cargill, if I come out to see you to play the video, are you going to see me?
At this point, I don't want an attorney.
You what?
I do not want an attorney. You're stating
At
things
all?
that are not true. You came up here and you were how late? So yeah, I was no longer at control center an hour after the time that was scheduled. You're right, but it's not that I refused to see you. I sat up here for an hour yesterday. You did not show up. You were late. Extreme.
And here it is, the turning point of the entire session. Defendant Alicia Cargill is refusing legal counsel and wants to represent herself. That's called going pro se, and it's risky business. The judge immediately warns her about the dangers. She'll be held to the same legal standards as a trained attorney. But notice her frustration. She feels unheard, claims she hasn't received discovery, and insists her lawyer was late. This is a textbook clash of mistrust between client and counsel. In moments like this, judges have to walk a tightrope, balancing a defendant's right to self-representation with their duty to ensure a fair trial. Viewers, what do you think? Should the judge have allowed her to go solo or stepped in for her protection? Drop your thoughts below. This one's a tough call.
So miss me with that. I don't want no
hold on.
attorney. I can
Ms.
represent myself.
Ms. Cargill, hold on. So is it right now that you don't want an attorney at all? Or?
Yeah, at this point, I can represent myself. He still hasn't sent me my discovery. He came out here over a month ago. I asked for a discovery. I'm yet to receive any paperwork about this case at all. I don't know anything that's going on.
Okay, so you want to represent yourself?
Yes.
Okay, I'd have to advise you that might not be advisable to represent yourself in this case. You are charged with the offense of assault with intent to do great bodily harm less than murder or by strangulation. That is a felony punishable by up to 10 years incarceration and or a $5,000 fine plus court costs. Do you understand all of that?
No, because when I got arraigned, that's not what I was charged with.
You understand also that if you do represent yourself, you will be held to the same standards as any attorney, that the court will not be assisting you in any way in your representation. You understand that, sir?
I do not want this attorney. So it doesn't, at the end of the day, and then you're sitting here telling me new charges that's not what I was arraigned under. I was arraigned under assault or whatever with less than whatever. Nothing with strangulation.
Sir,
this is news.
Ma'am,
so I'm confused.
That's the charge that I have before me. That's why I'm apprising you of what the charges are. You wish to represent yourself. I told you that you will be held to the same standards. The court would also indicate that if at some time you wish to be to have the representation of counsel, you need to just request that of the court, and the court will oblige and make sure that you are represented by counsel. Do you understand all of that?
I understand everything you're saying.
Okay. So what do you wish for me to do today? Adjourn the matter so you can get discovery, or what do you want me to do?
I mean, I want my discovery I'm entitled to. I want to be represented properly if I'm going to be represented. I don't want to hear, I don't understand. So,
you want me to adjourn the matter out so that you can get all that information and make your decision, or what do you want me to do?
I can't go in the breakout room with my attorney or anything? I'm confused. I don't get this.
I am not going to do that, sir, ma'am.
Okay, well, I'm not I didn't consent to Zoom either, so I don't know what's going on.
Judge, I'm just for the record, never mind. I'm not trying to get into argument. We went over the discovery. I was 10 minutes late yesterday. They could not find it to play my disc. That was the delay, Mr. Cargill. Now, I sat there for close to 45 minutes before they told me they had a computer to play your disc.
Well, I think you need to get the discovery to the person. I am going to find good cause to adjourn this proceeding since nobody will give me an answer what they want to do. I will adjourn it 2 weeks out. I need 2 weeks for the writ in any event. So it's going to have to be October 16th, that following Thursday from the Tuesday. October 16th, 2025, 9 a.m. Bond continued. Thank you.
I'm sorry, I'm on vacation.
Well, they wants to represent himself. I don't know what you guys are going to do. I'm setting it for that date. You can talk to each other, make your decision. If it looks like you are going to be representing this individual, Mr. Killowald, then certainly you can seek an adjournment from the prosecutor to set a date. Thank you. I'll continue.
And that brings this intense session to a close. The judge ultimately adjourns the case, giving Alicia time to get her discovery and make a final decision, whether to represent herself or stick with counsel. It's a fascinating look into how courtroom patience, procedure, and human emotion collide. From scheduling chaos to serious felony charges, this hearing had everything: tension, confusion, humor, and real stakes. And remember, behind every quick ruling and every heated exchange are people fighting for control over their lives and futures. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, And don't forget to subscribe for more jaw-dropping courtroom breakdowns, only here on Courtroom Clashes.